Welcome everyone to another Yukon Law Society CPD event. Today, I'm pleased to be the Law Society of Yukon's Continuing Professional Development Committee is pleased to present Insolvency 101 with Chris Sinclair, CPD, CA, CIRP, and LIT or LIT. I'm not sure which one that is. Chris will be talking about a variety of topics and give a brief overview of the options for debtors, creditors, industrial trends, and the like. But I'll let him get into that, and I'll give a brief introduction to Chris. Chris oversees BDO's insolvency practice in British Columbia, including BC Interior Region, Greater Vancouver area. He is also licensed to practice in Yukon. Chris has been advising businesses and individuals on insolvency matters since 2009. He spent the first 8 years of his insolvency career working with businesses and companies to restructure their debt through court-appointed receivership, propose creditors, bankruptcy, and other non-legislative solutions. Since 2017, Chris has been helping individuals and small businesses navigate the difficult but rewarding process of debtor relief. Through his wide range of experiences, Chris can bring an empathetic and practical approach to solving problems. He solve problems and he provides his clients with solutions that are tailored to their specific situations and meet the client's current and future objectives. Chris obtained a Chartered Professional Accountants designation in 2008 and has been a member of the Canadian Association of Insolvency and Restructuring Professionals since 2014. In his spare time, he likes to volunteer with Little League Baseball associations and enjoys spending time on the golf course. The CPD is worth 1 hour and 30 minutes by the Law Society of BC and can be applied to both Yukon and BC. Chris, just before you get started, do you prefer to hold everything until the end or take questions as they come up?
I was afraid you were going to ask me that. I think why don't we hold it till the end? I
Okay.
do plan on leaving time at the end for some questions. So if everybody's okay with that, why don't we just leave it till the end?
Okay. Good. And I'll get my ugly mug off the screen like
Thank you so much for that. Good afternoon, everybody. It's a pleasure to be presenting for you today. When Lynn first reached out, I think it was 3 months ago, I was quite excited the opportunity to speak to you all today. I recently had my license extended to the Yukon, actually through someone else leaving the firm here. So I'm now licensed, as the intro said, in British Columbia and the Yukon. BDO does have, some of you may be aware, a little office in Whitehorse, primarily staffed by sort of our assurance folks, maybe our small business people. But we do have an office there, so perhaps I will see some of you one day. We're going to be talking about a few different topics today, and I'm always a little hesitant when it comes to a group of professionals, particularly lawyers, because I'm not sure your range of experience in insolvency matters. So we've put together a little deck here called Insolvency 101. I hope it's useful for you. As all of you could talk about hours, days, weeks, your particular practice areas, this is just going to scratch the surface, right? So I'll cover some highlights here. Certainly not going to cover it all. As I said, there'll be questions at the end. I just want to mention before we start, this is definitely more of primarily a consumer insolvency focused presentation, although I did practice corporate insolvency for a number of years. And if there's any burning questions on the corporate front, we can certainly quickly cover those at the end. Or if you have any corporate restructuring questions, you can always reach me offline as well. I did promise my partner in the business restructuring group that I would give them a shout out today. So there we go. Business restructuring questions, feel free later, okay? But mostly consumer talk today. So today, what we're going to be talking about, a little bit of an introduction about the insolvency system. We'll talk about some of the options available to debtors and the effects of those options. We'll talk a bit about discharges in a bankruptcy setting, like an individual getting a discharge from bankruptcy and the effect of that and some things that can happen. We'll talk briefly about creditor options. In other words, what can a creditor do to protect their interests or take certain actions with respect to the Bankruptcy and Insolvency Act outside of their standard legal remedies, which of course they have no matter what. We'll talk a little bit about trustee fees, just as an interest area for you. Sometimes we charge hourly, but most of the time we don't. So we're a little bit different from you folks most of the time. I'll explain more. We'll cover a little bit about death estates, family law, which is I'll get into it later. The intersection of family law and bankruptcy law can be quite messy. So I hope we have some family lawyers on the call, because I reserve the right. I'm just going to say it right now. I reserve the right to throw questions to the lawyers on this topic. I'll cover a couple industry hot topics, just for interest's sake, and then we'll get into the question period. So hopefully that's a cross section of my world. Very briefly, so why do people reach out to us? There's a number of reasons. Unfortunately, something we're fighting all the time as licensed insolvency trustees is the misconception that people are dishonest or try to get into these situations. And although I'll say the odd time there's some dishonesty or malfeasance or some sort of negligent act, most of the time, I'll be honest with you, most of the time, we are helping what we call the honest and unfortunate debtor, which is a key pillar of the Bankruptcy and Insolvency Act, which I'll call the BIA from now on. So the BIA does exist to help honest and unfortunate debtors restructure their debt and get a fresh financial start. That's the underlying theory of everything we do. So most of the time, honest and unfortunate, okay? I know everybody probably doesn't believe me, but that's what we see. So overuse of credit. I'll come back to tax debt in a minute. Perhaps a creditor action forces people to call us, right? The pressure's on, some sort of foreclosure or other creditor seeking a judgment. Payday loan cycle. People really get caught up in this, where they start borrowing from these high interest lenders. Money Mart, Easy Financial, Fairstone. I know I'm calling some of them out, but these are higher interest loans. And once people get on these cycles, it's very difficult to get off. Loss of income, which can come from a number of different things. Just simply job loss, unemployment, industry factors. Currently, in the news every day is the tariffs, right? So that's having effect on certain industries. Downsizing, I think I saw the other day that the Canadian unemployment rate has ticked up to the highest it's been since pre-pandemic. Illness, marital breakdown, lots of that. And of course, we're going to cover family law a little bit later, but separation, divorce is one of those major life financial events that can have a very adverse consequences on people. Business failure, very common. And oftentimes, my second bullet point above, tax debt and business failure sort of go hand in hand, because oftentimes what we see is clients, either sole proprietors or corporation owners, once they get behind, what they'll start to do is they'll start to finance their operations using the government. And what do I mean by that? They stop paying GST and they stop paying source deductions. Not always, but a lot of the time, okay? So the government CRA ends up financing these businesses indirectly and unwillingly until it's too late. And then, of course, lots of times we see just business owners with a lot of personal tax debt as well. And I'll cover personal tax debt when we get to the discharge part, because if there's a substantial personal tax debt with CRA, it can affect the discharge. Garnishment, I kind of covered legal actions earlier. Oftentimes, what we see, and I'm chuckling a bit, clients will be subject to a garnishment action, or sorry, that a creditor will get judgment, and the debtor won't really do anything. But as soon as the creditor gets a garnishing order, the person will call us, right? Because as soon as it hits their paycheck, 30% or whatever it is, boom, the person can't survive anymore, so they have to call. So a lot of these factors are reasons people will call our office looking for help. What's an insolvency proceeding about? Some different players here, primarily the debtor and the creditors. From the debtor's perspective, they get a stay of proceedings, creditor protection. So whether they file a proposal, which is a debt restructuring plan, or a bankruptcy, they're going to get a stay of proceedings. It stops all actions against them. Any court proceedings, judgments, garnishing orders, even CRA. it'll stop the creditors from pursuing debt claims. The debtor has to do some financial counseling sessions. There's two little sessions to do, whether you file a bankruptcy or a proposal. The effectiveness of those can be debated. And I don't say that in a negative sense, but part of the insolvency counseling program is intended to prevent Canadians from reusing the process. But we do see a lot of second-time bankruptcy filers and second-time proposal filers, or even third-time filers. Or perhaps a person has one proposal, one bankruptcy, that they come back. So that's why I made the comment that the counseling program is sometimes successful, but not always. The debtor's ultimate goal is to discharge their debts. So whether that be a bankruptcy discharge or obtaining their what we call a certificate of full performance, which is when a debtor does a proposal, they pay their, let's say it's a 5-year proposal, they pay their amounts as agreed to with the creditors. Once they're done paying, they get this certificate of full performance and their debts are legally discharged. So that's the whole goal here. Discharge the debts, get a fresh start. From the creditor's perspective, a little different. There's an information piece to this, and I'll talk a little bit more about the role of the trustee because we're key in balancing these interests. The creditor wants information. They want good information from debtors. There's an asset piece to this. So particularly in a bankruptcy, assets will vest in the trustee. I'm going to cover that in a minute. In a proposal, assets do not vest. So the debtor in a proposal, in a debt restructuring, keeps their assets, which is really important and a big factor why we're seeing a lot more proposals these days, which I'll also cover that in a little bit. And then, of course, the creditors are entitled to distributions on an equitable basis, pro rata. So unsecured creditors share pro rata in the distributions from either bankruptcies or proposals, which can vary widely. Sometimes there's no recoveries in a bankruptcy. Sometimes there's substantial recoveries. Often, well, always a proposal offers a recovery to the creditors, and oftentimes a proposal offers a better recovery for the creditors. Fairness, creditors need to be paid, but debtors at the same time should pay what they can, and debtors are entitled, as I mentioned earlier, to a fresh start under the Act. And then there's, of course, the rules. We all have rules. You guys are part of the Law Society. I have rules. I'm licensed by the federal government of Canada, the Office of the Superintendent of Bankruptcy, which is the federal regulator overseeing the entire insolvency system in Canada. We answer to the OSB. There's lots of checks and balances in place in the system. There's ways to complain about various things. A debtor can file a complaint about a creditor can complain about a debtor, anybody can complain about a trustee. And the OSB is empowered to do examinations and investigations. So there's a whole integrity oversight piece to this, as you probably could have guessed. The fundamental purposes of the Act, I've already mentioned a couple of them. I talked about the honest and unfortunate debtor needing a fresh start. Part of this is also the credit cycle, right? So I always see a big part of a trustee's job is to get money back into the credit system. So that means financially rehabilitating the debtors, get them on a plan. What we don't want, or what creditors don't want, and I certainly don't want, is somebody sitting at home or wherever, and the collection calls are ringing 20 times a day, and they're paralyzed by it. They can't do anything, and they're not really paying. They don't know what to do. It's just not good for anybody. So these processes are intended to get some money flowing, get some money back in the system. The creditors may not get a full recovery. They're probably not going to. At least they're going to get a recovery, and then they can re-lend the money and just keep the cycle moving. I talked about counseling. Counseling does play a role in rehabilitation, often, not always, as I mentioned. We want to ensure that creditors have adequate information about the process, the debtor's affairs. What's interesting is there is a big self-policing component to what we do. And I always say that, oftentimes, most people, as I mentioned earlier, are very honest. But I know that sometimes we don't get the whole story. But I feel okay about it because a lot of the times, the self-policing system, the creditors tend to know more about the debtor than I do. So stuff will come out of the woodwork during the process. A creditor will raise questions or issues or flag something that happened. And then things get a little messy because then I have to go back to the debtor and ask what happened. And then, they've sort of been exposed for whatever happened. So the creditors, I always encourage creditors to take part in the process and give us what information they have if there's information missing from the statutory documents. We are here to provide an orderly and fair distribution of the bankrupt's property or a debt restructuring, a proposal. And there's mechanisms in the BIA for investigations to be made of the debtor and his or her affairs. There's ways to deal with preferences, financial transactions, fraudulent transactions. There's a whole piece in the BIA that talks about how to deal with transfers at undervalue, meaning assets were transferred for little or not market value, or preferences, one creditor was paid when another wasn't. There's all ways to deal with this. And we provide a regime where creditors can pursue their claims against the debtor in a structured and legal process. The role of trustees. I always call it a bit of we walk a tightrope. And you see the last point there. We're sort of the referee in this tug of war between the debtors and the creditors. In fact, I guess the Office of the Superintendent of Bankruptcy is the referee, but we are always having to balance the interests of all the stakeholders. And I always found as a younger or new trustee that to be difficult. And you all have your practice areas, and as you learn, you kind of get better at balancing everyone's interests. But we are officers of the court, so we're always often in court, giving evidence, making affidavits. We have to give fair and impartial information to the court. There's a slew of ethics. There's the Bankruptcy and Insolvency Act general rules. We have the Canadian Association of Insolvency and Restructuring professional standards. There's a whole host of ethical things we have to adhere to, just like all of you. I won't cover that too much because I know who I'm speaking with. We have a responsibility to conduct what's called an assessment of the debtor. So what that means is when I meet a consumer, a client, whatever you want to call them, a debtor, there's actually, I think it's Directive 6 under the BIA. There's a directive that talks about the assessment, and that's where the trustee has to perform an investigation of the person's affairs and ask the right questions and make sure we sort of outline their options for them. And they're fully informed, and typically the debtor ends up picking between a bankruptcy or a consumer proposal. I will cover the differences between a consumer proposal and a Division 1 proposal shortly. But oftentimes, back to my point, I would tell you that I don't have a statistical number on this, but I would say a vast majority of the time, by the time a consumer calls our office, they very likely need our services. Okay. Now, some people talk to us, they don't really like what they hear. They don't like how much they're going to have to pay to get out of this. Lot of concerns about credit scores, which is interesting because I'll talk to people that have 50, 100, 150, $200,000 of debt, which you would think would be the biggest stressor in their life. But no, it's that three-digit credit score on Equifax. And they're very concerned about their credit score taking a hit rather than dealing with the big problem, right? Which is the debt. So it's always, that's a bit of a barrier to the process. I find is we have to talk people through this thing about focus on the big problem, and the credit rebuilding is going to have to come later. You'd be surprised though. People are very concerned about that credit score. Proposal or bankruptcy, very rarely someone might leave a consultation call and sort of think they can go off and find a different way. Maybe it's budgeting. Maybe they need to control their expenses. Maybe they need to get a second job. Maybe they don't have too much debt that they can avoid a formal insolvency process under the BIA. But almost always by the time they call us, they've already looked into other options. They've looked into consolidation. They've talked to family and friends. They try to avoid us as much as they can. So my only point is, I think by the time people call us, that they really need one of these two processes. We represent the interest of unsecured creditors. So these insolvency processes that I'm referring to, bankruptcy or consumer proposal for unsecured creditors. Secured creditors, of course, have their legal rights outside of the BIA, oftentimes under provincial legislation. And as I said earlier, we're the referee. So we have to make sure everybody's telling the truth, doing the right thing. It can be difficult, but I think we do a pretty good job. Okay, so in terms of the options, I've been kind of ranting about bankruptcies and proposals. In a bankruptcy, assets vest in the trustee unless they are exempt. So exemptions are by province. I'm going to come back to your province in a couple of minutes here because there's an issue there. But each of the provinces has different exemptions. So depending on the asset category, certain things are exempt, certain things are realizable by a trustee. There's two pots of money, as you can see on my slide here, that can come into a bankruptcy. One is non-exempt assets. The second is what we call surplus income. I did have a slide on surplus income. I found it to be it was a bit too in the weeds, but just generally speaking, surplus income is a there's a federal standard. The OSB sets what we call the minimum living standard by family size. So there's an amount of money that's the minimum expected living standard. Now there's problems there, which I won't get too much on my soapbox here, but it's a federal standard. It's not by region. So you can imagine that someone living, say, in Vancouver, where the cost of living is very expensive, rents are very high, or Toronto, or sort of the cities, they might have a harder time with this calculation. Because I'll give you one of the numbers. For a family of one, for a single person, and the standards change every April, so they just changed about a month ago. For one person, the minimum living standard is deemed to be $2,666. Okay, so think about that for a sec. $2,666. And if you're living in Vancouver, if you're a single person and you have a one-bedroom apartment, you're probably paying, unfortunately, close to that. So a huge percentage of this deemed minimum living standard is sucked up by your rent. Or in some people have mortgages, so big costs there, right? So the bankruptcy surplus income calculation can be quite punitive in some cases, because the theory is the bankrupt's going to pay 50 cents of every dollar they earn over that minimum amount. So for the single person I just told you about, if she earns $3,600 a month, we subtract the standard, which I'm going to round down to 2,600, divide it in two, 50%. This person's going to pay $500 a month in the bankruptcy, 50 cents on the dollar for every dollar over the standard. So that number can get quite punitive depending on a person's income. And if they have high costs of living, this is one of the reasons why more and more people are filing consumer proposals as opposed to bankruptcies, because they cannot manage this calculation. So assets surplus income goes into the pot, and that's the pool of money available for the creditors in a bankruptcy. A proposal's a far different process, and I'll be honest, most of my slides are geared more towards bankruptcies, because I would say more legal issues come out of bankruptcies. Proposals are a front end process where we meet the person, the debtor, collect their information. It's a negotiation process, so they take a deal out to the creditors. And there's an initial period, which is 45 days, where the creditors have to consider the proposal. And in a consumer proposal, which is for debts under $250,000, the debtor only needs a majority of creditors to say yes on the basis of the dollar value of the claims. So if they have $100,000 in unsecured debt, they basically need $50,001 worth of creditors to say yes. If they get 50% plus one, consumer proposal is approved. There's no vesting of assets in a proposal. So you can imagine when we're talking to people and we're outlining the options, if they have a house or some sort of substantial asset, they're not going to want to file bankruptcy. They're going to want to keep their assets, protect the assets. There's no vesting. And what they're going to do instead is they're going to offer their creditors a payment that's going to factor in the value of those assets, but it's going to give them 5 years to make that payment. Consumer proposals cannot exceed 5 years in duration under the BIA. And I would tell you that I think a little bit before my time in consumer insolvency, but the BIA, some of the legislation changed substantially in 2009. So it's been about, 15, 16 years now. And consumer proposals have become widely used. And I would tell you that creditors, they're used to 5 years. Anytime if a debtor offers a creditor less than 5 years in duration, in term, they're probably not going to accept it. So 5 years maximum, but through practice and all these proposals that are being filed across the country, the creditors just want 5 years. So I'm assuming when I talk about this stuff that it's a 5-year plan, okay? Doesn't have to be, but usually it will be. A proposal is often a monthly payment over 5 years. There can be a lump sum component. Proposals are very flexible. Trustees like them, as do the debtors, because you can be quite flexible in payment terms. You could do a partial lump sum and a partial monthly. There is such thing as a lump sum proposal, which actually isn't 5 years. A debtor can go to a creditor and makes an offer now. I'm going to give you X, 40% recovery today. You're not going to wait 5 years. Let's do it now. That can be successful, although there's some challenges around that. It depends on the person's situation. You can structure payment terms differently. For example, school teachers. I think in BC here, I think they tend to get paid for the 10 months of the year. They do not, some of them don't get paid in the summer. So you could structure a proposal whereas the debtor's paying 10 months of the year and then they get 2 months off in the summer months. There's just an example of the flexibility around payment terms. If a person has over $250,000 of unsecured debt, let me rephrase that. If a person has over $250,000 of debt, excluding debt secured by the principal residence, i.e. a mortgage on your primary residence. So if a person has $700,000 of debt, but $500,000 of which comes from the mortgage, okay, they can file a consumer proposal. They're under 250. However, if that person has a rental property that they do not live in, and they have a mortgage on the rental property, they are going to be over that $250,000 threshold, and they're going to have to file a Division 1 proposal. A Division 1 proposal is, I call it the big proposal, and the stakes are higher. There's some differences in the rules, which I won't really bore you with, but the key difference, I would say, is a shorter voting period. It's about half the time where the creditors get to vote before there's a mandatory meeting of creditors. And the stakes are higher because if the creditors do not accept the Division 1 proposal, there's an automatic bankruptcy. So if a client files a Division 1 proposal, they need to go in knowing that if it's unsuccessful, they will be automatically bankrupt. In a consumer proposal, there's no automatic bankruptcy rule. So if the proposal doesn't work out, it's not the best because the client's back to square one. They don't have a solution. They have all this debt, but there's other things they can do at that point. They could file a second consumer proposal under the BIA. They could file a bankruptcy at that point. So my point to you is the stakes are higher in a Division 1. A notice of intention, probably more common in a corporate restructuring scenario, but a notice of intention it's a mechanism under the BIA for a company or a consumer debtor to get an initial stay of proceedings for a period of 30 days. It's a notice of intention to file a proposal. So you're telling the creditors, hey, a proposal's coming, I just need a bit of time to put it together. NOIs, notice of intentions, can be extended by court order, but they cannot be extended further than 6 months. So it's a maximum 6 month stay to be able to prepare a proposal. It can get quite complicated in a corporate setting. I don't think I've ever done a notice of intention for a consumer. Maybe once. I'd have to think hard about that. There'd have to be a very good reason. Typically, consumer affairs are more simple than a corporation, so you can typically just go straight to the proposal stage. But I guess if there was a real urgency around a CRA garnishment or something, a notice of intention could be filed to get a stay of proceedings. Let's talk about bankruptcy a little bit, and I'll talk about assets. So a lot of the people we talk to don't have a lot of assets. And if they do, as I mentioned earlier, they're probably leaning toward a consumer proposal, a debt restructuring plan with the creditors. So as I said earlier, the bankrupt's property vests in the trustee, except for exempt property under provincial and federal legislation. So generally what's exempt varies by province. RSPs are typically exempt except for the last 12 months of contributions. Registered disability savings plans, I probably different across the country. I'll be honest, when I don't know something, I'm happy to be honest about. I don't know the treatment of our DSPs in the Yukon. I do know in BC there's a court decision about that. And effectively, they're not legislatively exempt, but that court ruling, and it was a few years ago, I'd have to look it up, but effectively they were practically exempt and trustees don't really want to touch it for social reasons, if you could say that, but our DSPs are a tough one to realize on. In the Yukon, so, and I spoke with someone from the province months ago because I know there's a process underway to modernize the Exemptions Act in the Yukon. I would say your exemptions are badly lagging, they're very low, and they're quite punitive to people pursuing the insolvency process. And I'll give you an example. Principal residence, $3,000 exemption in the Yukon. In Alberta, it's 40,000, which sounds like a lot to me being in BC, because in BC, it's $12,000 in the cities, Greater Vancouver or the Capital Regional District, which is Victoria, and 9,000 pretty much everywhere else. But 3,000 is very low for a principal residence. Tools of the trade is $10,000 in BC, $600 in the Yukon. Household furnishings and clothing generally exempt, and a vehicle is that's comparable to BC. But I think as of last April 2024, the new legislation is on the government website, but it seems to me that it's not been. I'm not sure what the term is, whether there's been assent or whether it's. I don't think it's received full approval. So we're still operating under the legacy exemptions. I do think the Exemptions Act will be updated soon, hopefully this year. It'll make things easier on people. With respect to the stay of proceedings, so I mentioned any insolvency process, there's a stay of proceedings. Any proceeding against the debtor, court actions, garnishments, what have you, are halted with respect to claims that are provable in bankruptcy. Except that, there's always exceptions. Support payments, child and spousal support. Those debts can continue to be collected. In BC, it's called Family Maintenance Enforcement Program. I think in the Yukon, it's just MEP, Maintenance Enforcement Program. Contracts that are good standing can't be canceled simply due to the fact of bankruptcy. And we've seen creditors try to do that, but they can't do that. So what it does is it sort of puts a box around. I'm using my hands because I'm standing up, moving around here. Puts a box around the situation and protects the debtor, and gives them the opportunity to restructure their affairs, get through the process. Now the debtor has responsibilities too, which I'll come back to in the discharge part. But it gives them the breathing room to be able to deal with the debt in an organized manner. There's a whole bunch of discharge periods. The Act, the BIA says that for a first-time bankrupt, they will be in bankruptcy either 9 months or 21 months, depending on whether they have what we talked about earlier, which is, so surplus income is the determining factor of the length of the bankruptcy. So first time, no surplus, 9 months, very quick. I sort of call it a person's reward, if you will, for never having filed bankruptcy before, and they don't really have a lot of money. So they're in and out pretty quickly. If a first-time bankrupt has surplus income, then they're looking at 21 months, which is still pretty short. It's under 2 years. A second-time bankrupt, 24 months, 2 years if they don't have surplus income, 36 months, 3 years if they do. Then things, so those are automatic discharges. First time, second time are entitled to automatic discharges, meaning if they go through the process, do their duties, report their income. So a key part of the bankruptcy process is the bankrupt filing monthly reports with the trustee office to tell us what their monthly income is. And that's how we track the income and determine how long they should be in bankruptcy. They have to do their 2 little insolvency counseling sessions, which I mentioned before. There's other things, they have to disclose their assets and perhaps help the trustee and with any investigations or whatever. But generally speaking, if the bankrupt holds up their end, they are entitled as a first or second time bankrupt to an automatic discharge. If nothing goes wrong along the way, out they go. It's quite anticlimactic. So on that last day of the pertinent period, whether it be 9 months or 21 months or 24 months, whatever, our office issues a discharge certificate, file it with the Office of the Superintendent of Bankruptcy, and boom, that person's done the bankruptcy, they're discharged, and the debts are legally discharged at that time. For multiple users of the process, like a third time bankrupt, fourth time bankrupt, things start to get more murky. A third time or more, not entitled to an automatic discharge. So on those files, the trustee, what we would typically do is around the 9th, this is just a matter of practice, around the 9th month, we would make a court application to generally adjourn the discharge, meaning we need terms. And oftentimes those files, like a third time, fourth time, will result in extended period of payments or perhaps other conditions, but those people are not getting an automatic discharge. They're going to be in the process longer. and there's a good chance they're going to end up paying more, probably through a conditional order of discharge. Income tax debt. If a debtor has over $200,000 of personal tax debt, not GST or payroll debt, personal tax debt, and that personal debt, tax debt represents 75% or more of the total debt, they fall under section 172.1 of the BIA, and they're called a personal income tax debtor, or we call them a high tax debtor. So if a person's a high tax debtor, CRA has enhanced rights. There's an automatic opposition to the discharge, so that person is not getting an automatic discharge. And we're probably, again, in practice, going to end up in court, and Department DOJ is going to be there representing CRA, and hopefully the bankrupt has independent counsel, but not always. And there's going to be a fight, and the person's probably going to end up on a conditional order of discharge, paying some percentage of the tax debt back over some period of time. That can vary widely. Conditional orders can last 1 year, 2 years, 5 years, 10 years, which is kind of scary. But so it really depends on the situation. But just know that for a high tax debtor, CRA does have enhanced rights on those files. There's lots of different ways this can play out. I could talk about this a long time. Creditors can oppose a discharge. A trustee can oppose a discharge. There's certain facts in the BIA that give us reasons why we would want to do that. You can probably imagine some of them. Dishonesty, not assisting in the process, hiding assets, not reporting their income. These are some common things. Not doing their little insolvency counseling sessions. These are some common reasons why a bankrupt's discharge is opposed by the trustee. So in those cases, off to bankruptcy court we go, have to have a discharge hearing, and typically terms will be put in place. The person's going to have to complete the duties that they did not complete, or comply in other ways, perhaps make a payment. They may have their discharge suspended. So there's lots of different things that can happen here. And speaking of which, this is a good segue into the next slides. Types of discharge orders. So an absolute is when the bankrupt has done everything that they should have done, were supposed to do. They get their absolute discharge, so off they go, their debts are gone. Suspended, typically maybe 6 months, 12 months, it depends on the circumstances and what's happened, but discharges can be suspended by the court. A conditional discharge is, of course, certain conditions must be met, and oftentimes that means payment terms. So very frequently, a conditional order of discharge will have some sort of monthly payment in it for some period of time. The bankrupt's making restitution to the creditors. Or what can sometimes happen on the point of a conditional order, if the bankrupt is unable to pay the required surplus income during the term of the bankruptcy. So I'll give you an example for a first-time bankrupt, 21 months. If they had high calculated surplus income payments and they weren't able to pay it, they may end up on a conditional order, meaning they haven't got their discharge and they just need more time to pay what they should have paid. Or perhaps there's asset issues that need to be resolved. Fortunately, I've never had a bankrupt have their discharge refused, but it can happen. A well-publicized recent one, and maybe some of you have heard of this, the Poonian case, which was the BC Securities matter that went to the Supreme Court of Canada. There was a local lawyer and a local insolvency lawyer in Vancouver who was acting for the bankrupt, the Poonians. I believe their discharge was refused by the court, so they're sort of stuck in bankruptcy for who knows how long. And there's a whole bunch of issues on that one, but interesting case there. So when it comes time, what I've been talking about is typically the debtors will drive the bus. They're the ones calling in, seeking options to get out of debt, but the creditors have options too. A common one that we're seeing a little bit more lately is under Section 43 of the BIA. Creditors can force a bankruptcy. We call it a bankruptcy petition. They can make an application to court to adjudge a consumer as bankrupt. So often the ones I usually see there are typically stemming from personal guarantees from a failed business. So the bank may have put a receiver in the company, or perhaps the bank has bankrupted the company, and then there's a personal guarantor with a significant amount of debt, and they're not really cooperating, not giving information. The creditor can petition the person into bankruptcy. then a trustee is going to deal with it, and the person's going to go into the regular bankruptcy process, just a different way, creditor forced. Creditors vote in proposals. So lots of proposals these days, and I really encourage creditors to take part in the process, lodge their vote in proposals. The only way to have a voice is to vote. In consumer proposals, I told you it's a majority situation. So 50% plus one. In a division one proposal, the bigger proposal, the voting threshold's a little bit different. There's two tests. You need a majority of creditors in head count to agree. And then you also need 66.667% of creditors in dollar value to agree. You need both of those things. So a bit higher of a voting threshold in a division one. Creditors can seek examinations of debtors. They can request the trustee to do it. They could lodge a complaint through the Office of Superintendent of Bankruptcy or request an examination under oath. Creditors can act as inspectors. So an inspector is a way for a creditor to sort of monitor the file and the trust and keep in communication with the trustee. There's periodic inspector meetings. Again, more common in a corporate insolvency situation, but you can have a number of inspectors on a file, which is I'll say, by the way, very rare in a summary administration bankruptcy or a consumer proposal. Very rare to have an inspector. Most creditors tend to just let the process happen. In some cases, and this is a bit, I could probably talk longer about this one, but there's a section under the Act, Section 38, where if a trustee doesn't wish to pursue an action or probably isn't funded to, a creditor can take an action in its own name and continue an action sort of in the bankruptcy process, but in its own name through court order. So if the trustee steps away from litigation or some sort of asset pursuit, if a creditor wants to carry on with it, they can get a court order and keep doing it themselves at their own cost, but also their own benefit. And then discharge oppositions, which we covered earlier. That's a way for creditors to continue to have a say in the process if they're not happy about something, if they're aware of some sort of malfeasance, or so many ways this could happen. But a creditor can file an opposition with the trustee, block the automatic discharge, and then off we go to bankruptcy court, and everybody has their say there. Trustee fees. So I mentioned earlier, we don't often charge the way lawyers do, but sometimes. So most of our files are summary administration bankruptcies, which means net realizable assets below $15,000. Not surplus income, just net realizable assets. So if a bankrupt has less than $15,000 of realizable assets, that's going to be a summary simple administration. And in a summary administration, there's a tariff set by the Act. It's a sliding scale. Testing me here. I think the trustee gets the first $975, and then 35% of the next $1,000, and then 50% of the difference after that. But it maxes out at about $7,800. So on a bankruptcy, on a summary administration bankruptcy, the highest trustee fees will be around $7,800. Can't go higher. Consumer proposal is a little different. It's the same every time. It's $1,500, so it's $750 on filing, $750 on deemed court approval, and then 20% of amounts distributed to creditors. So you can see there that the higher the proposal bucket, meaning the amount that the debtor's paying in, the higher the recovery for the creditors, the higher the trustee fees. We take some criticism for that, our industry, at times, because you can imagine the knock. It's, well, you guys are juicing the debtors. You want the recoveries to be higher, so your fees can be higher. My answer to that is we need a system. So this is the system under the Act. You could argue it's too low. Some of us might argue it's too low. Some of us would argue it's too high. But this is the way it is. That's my first rebuttal. And then my next rebuttal is, these debtors should pay a fair and reasonable recovery to their creditors. And some debtors can afford more than others. There's some fairly large consumer proposals. Some consumer proposals are $300 a month for 5 years, but others are $1,000 a month or $2,000 a month. So fairness, a debtor should pay back what they can. and the trustee fees just sort of flow from that. As an industry, we are responsible to assess the situation, give the debtor their options, and try to advise on the best uh, plan for them and the creditors. I think as a trustee, and this might sound naive, but if you're starting to act in the best interest of your fees, you're going to get in trouble. I think you need to give people the best possible advice. I'll talk a little bit more about an industry trend around this, okay? And I don't want to ruin one of my future slides. Again, with these summary processes, summary administration, consumer proposals, smaller processes, there's a summary taxation process for these files. So we have to submit all our accounting, our fees, whatever came into the estate. We submit all of this accounting to the Office of Superintendent of Bankruptcy, but it's taxed on a summary basis by the OSB. They send a letter of comment, it's called, to the trustee. 99.9% of the time, the letter of comment is going to say you can proceed, all good. The odd time if something goes wrong on that file, if there's something's happened and they perhaps want to look at the fees, they can request the trustee to go to court. But almost always on a summary admin or consumer proposal, the fees just are taxed automatically and we don't go to court. Now, on the bigger files, ordinary administration bankruptcy, that's where the net realizable assets are in excess of $15,000. On those files, we're going to charge our fees on an hourly professional basis, just like you guys. So now those files are more rare. Most bankruptcies are summary admin, but the ordinary admins happen. The corporate guys, all of the corporate files are ordinary, so our corporate group charges hourly, just like lawyers, okay? But in the consumer practice, it's quite a bit more rare. Division 1 proposals, these can vary quite widely. And it depends on the size of the proposal. In these, of course, the debt's higher, so the recovery, the debtor payment might be higher. And trustees need to be careful on these, not to get too greedy. For instance, if we use this 20% number from a consumer proposal, which lots of trustees do, by the way, if that's a $400,000 file, in other words, if the debtor's paying back $400,000 over some period of time, 20% of that's about $80,000. There'll be other costs and stuff in there, but let's say $80,000. If that's a relatively smooth proposal, meaning there isn't a ton more work there than another file, my concern on those is, like, I'm always careful on what I put in for fees in Division 1 proposals, because I don't want to be going into court for taxation and having to justify to the judge why my fee was $80,000 for this file when maybe it could have been like 30, right? So there's some judgment there. You have to sort of make an assessment of what's in the file, how complicated is it, can I justify these fees? Ordinary administrations and Division 1 proposals, trustees have to go to court for taxation. We have to get taxation through the court. So those are a little bit different. Some bankruptcy files, probably for seniors or perhaps people on social assistance, they do not have assets and they don't have surplus income. So there's no recovery for creditors. It doesn't really make sense for these people to file a proposal. So they're probably going to file a bankruptcy. And in those cases, we ask the person to make a voluntary payment, which basically just means they're covering the minimum estate costs of the trustee. And a very common number you'll hear across Canada is a lot of those first-time bankruptcies, no income, no assets, probably $1,800, $200 a month for 9 months, kind of the basic fee. That hasn't changed in a long time. Oftentimes, if someone's on social assistance, maybe they have a friend or something. I mean, I feel a bit, those ones are tough because you feel a bit bad for the person, but we have to collect some sort of minimum costs. These days, with the way costs are, staffing costs, leasing costs, trustee firms will not stay in business doing $1,800 bankruptcies. We just won't. And that's a segue into a point I'm going to make later. I mentioned earlier the bankruptcy petition. So sometimes if a creditor wants to push the process or drive the process, they'll need to go find a trustee to agree to act on one of these files. And then, of course, the creditor has to fund, because we don't really necessarily know what the bankrupt has. So much like lawyers, we want a retainer in these situations. We don't know what we're getting ourselves into. So we're going to ask the creditor for some sum of money, 5, 10, 15 grand, depending on the complexity, to at least cover the trustee. Then, of course, later, if there's assets or surplus income and we can collect our fees from the pot of estate money, the creditor might get their money back. But oftentimes in those more complicated situations, we want a creditor to step in and fund it. I mentioned earlier the bigger files, the ordinary admins and the Div 1 proposals subject to taxation. There is varied jurisprudence across the country with respect to these, always makes me a bit nervous. I gave you the example earlier of the Division 1 proposal where the trustee might put in a percentage fee. We can also charge hourly, by the way. I didn't say that earlier. We can charge hourly for Division 1 proposals. But there was the Toronto in Ontario, the Toronto Court District, at some point in the last probably couple of years, has started asking trustees for detailed time records. Even if they have a percentage fee in the proposal, and remember the proposal is approved by the creditors. And once the creditors approve a Division 1 proposal, we have to go to court to get court approval of the proposal. So what's interesting is these fees were approved by the creditors, then they were approved by the court, but down the road in taxation, the court said, well, wait a minute, trustee, we want to see your detailed time records. And what they're really saying there is, have you actually done a lot of work on this file, or is your fee just sort of high? So that hasn't happened in, I'll say, in BC, but it could. So it always kind of worry me. So that's why I'm careful about what percentage fee I charge on a Division 1 proposal. Let's talk about death estates. So these are ordinary administrations. So I put on my slide there, the summary administration provisions don't apply to a death estate file. It's always an ordinary administration. Executors or administrators can assign the estate into bankruptcy. A creditor can also petition a death estate into bankruptcy, much like they could petition a living consumer into bankruptcy. The tests of insolvency still apply. So there's really two tests of insolvency. I call it the cash flow test and the balance sheet test. So can a person afford to meet their obligations as they generally come due? Can they pay their bills? That's sort of the cash flow test. The balance sheet test is, do their assets outweigh their liabilities, or are their liabilities in excess of their assets? Increased costs. So as I said, ordinary administration, that means the trustee's going to have to spend more time. There's some more statutory duties in an ordinary administration. There is a court taxation process. We have to spend more time at the end of the file to prepare our application to get our fees taxed. So the files are typically a little bit more expensive than a summary admin. Oftentimes, like we've done a few of these files, sometimes there's just, unfortunately, a mess left behind in the estate, and the executor or administrator might just want a licensed insolvency trustee to clean it up through an insolvency proceeding. Family members, or just as a question I've heard before, family members or beneficiaries can't assign the estate into bankruptcy. It has to be an executor or administrator, to my knowledge. It's a very quick rundown on death estates. I would say the few I've done have been pretty simple, and you know, they're basically just a regular bankruptcy, just in a death estate setting. Okay, the slide I was dreading. So where family law and bankruptcy intersect, it is a messy area of practice. A lot of stuff can go on here. I'm sure we probably have some family lawyers on the call here. What I find is, I always like, if a client consults me and they're going through a separation or a divorce, and they do have the ability to wait a little bit to resolve that proceeding, the family law proceeding, it's better to let the smoke clear, in my opinion, on the family law proceeding before you get into an insolvency process. Now, that's not always possible. Some matrimonial separations are very messy and highly contentious and can last for years. And an insolvent person may not have the ability to wait until the smoke clears to go into an insolvency proceeding. But most of the time, most people I talk to, again, I'm lots of generalizations today, but most people are down the road on their separation and things are getting cleaned up and they're close to having an agreement. And I'll usually say, you know what, go get your agreement done, call us back in 3 months, let's see where everything lands. That's the ideal setting. There's a few issues. So I've put a couple things down here. Equalization payments. These are provable claims in bankruptcy and may be discharged. So it's really important to remember that. So we're not talking about support. We're not talking about spousal support or child support. We're talking about asset equalization. And where this gets messy is in the aforementioned scenario where there's big litigation and the parties are at each other's throats. And we know there's assets and there's going to be some sort of equalization. The problem is the parties don't know where the numbers are going to land. So let's say Mr. comes and he files bankruptcy with BDO in the middle of this mess, and Mrs. has an equalization claim, and her counsel files a claim with the trustee. Well, there's a chance it's going to be an unliquidated or a contingent claim, meaning we don't know the value of this claim. There's a claim. It's probably quite clear there's a claim. Not always, but there's probably a claim. We just don't know what it is. And this can get quite tricky, obviously. Now, in a bankruptcy, because there's no creditor vote and there's no sort of fuse, if you will, for the vote. Remember, I told you there's a 21-day fuse in a Division 1 proposal before the creditor meeting. There's a 45-day voting period in a consumer proposal. So it's front-end loaded. Bankruptcy, we do have the benefit of time. We can let time pass. If there's certain matters unresolved, perhaps the bankrupt just doesn't get their discharge and he kind of stays in bankruptcy for a while. So a bankruptcy, you can certainly wait more. But the problem is in a proposal, for instance, if one of the spouses, the ex-spouses, comes in with a contingent claim on an equalization payment scenario, it can be very difficult to value that claim. And that claimant's going to want to vote. They're going to have a vote in the proposal, but the trustee has to value the claim. So you can imagine the things that might happen there. There can be disputes about whether the claim is, first of all, legitimate. I've put here, the claimant may struggle to prove their claim. The trustee may challenge the value or even the validity of the claim. This can get pretty messy. I've put here that if a court-ordered equalization has happened, if there's a court order, this really strengthens the position of the unsecured claimant. There's an order. It eliminates ambiguity surrounding this claim. It's probably valued and it's crystallized. There's a claim. There's a court order. So I like court-ordered equalization claims. I do not like contingent and unliquidated claims. They can be difficult to deal with. I won't talk too much more about that. Hopefully that makes sense to everybody. Now, with respect to spousal and child support, these claims, first of all, survive bankruptcy. So cannot discharge spousal or child support claims under Section 178 of the BIA. So that's good. The spousal and the child support claims are protected. Garnishment, ongoing garnishment. I mentioned the stay of proceedings earlier. These claims, spousal and child support, can continue to be collected during the bankruptcy. Not only do they survive the bankruptcy discharge, but they can continue to collect during the bankruptcy. And I mentioned these government bodies, FMAP in BC and Maintenance Enforcement Program in the Yukon. Up to 12 months of payment arrears are a preferred claim. So those rank higher than a regular unsecured claim in a bankruptcy process. And in other words, they might collect more money from the bankruptcy because they have preferred status. They're not secured, but they're preferred. Matrimonial property and asset division. Again, this can get quite messy. So the trustee, the vesting word, so when a debtor files bankruptcy, their assets, to the extent they're not exempt under provincial legislation, vest in the trustee. So the trustee steps into the shoes of the bankrupt, and then it becomes our job to deal with the assets. We can only claim, of course, the bankrupt's interest in matrimonial assets. If family court issues are unresolved, then we have to start to figure, okay, what are we going to do with these assets? Because trustees, we have to balance the interests of the stakeholder, but we're really there to get a recovery for the creditors. So we can't just abandon assets if there's potential assets there. So sometimes we might need to await court rulings or perhaps negotiate with a third party or the ex-spouse or their counsel, whatever the case may be, to try to come up with some sort of asset realization. We may have to call creditor meetings. There might be inspectors. I mentioned this. We might have to keep the inspectors abreast of what's happening. The negotiations can get quite complicated. It really depends where things are on the separation timeline. There's issues around the non-bankrupt spouse, the other spouse, asserting trust claims, constructive trust, exclusive possession. Um, I'm not a lawyer. I'm a lowly licensed insolvency trustee. So I'm not going to get too much into those things, but I have seen before, like the ex-spouse will say, well, maybe I wasn't on title but I paid X amount into the mortgage, or I think that's sort of a constructive trust argument. The possession piece is tricky because again, I'll go back to my Mr. Mrs. scenario where Mr. filed a bankruptcy. Let's say Mr. leaves the family home and he's a joint tenant. He's a 50% owner of the house, but Mrs. has stayed in the house, perhaps with the children or not. It's difficult if Mrs. doesn't want to leave the house and can afford the mortgage. Perhaps it's difficult for a trustee to get a recovery on that because we're going to have to try to um, perhaps force the ex-spouse out of the house with a petitioning order or what have you. This can get complicated. This can get costly. The trustee might have funding issues. There might not be enough money in the bankruptcy file for us to act. This comes back to the point I made earlier about a Section 38 application, where if a creditor wants to continue an action, they could potentially step into it and fund it. A creditor can either fund the trustee to do it, or a creditor can just take the action on themselves. But there's lots of issues here in family law. And of course, anytime things get complex between ex-spouses, all bets are off. I've just put a note at the bottom there. Bankruptcy does not override unresolved family rights to property. So this can be quite a tricky area of the law. My last slide here, I'll just spend a few minutes talking about hot topics in my industry, and then we should probably have about 20 minutes left for questions. So I put included but not limited to. I could talk about a lot more hot topics. The ratio of filings. So bankruptcies, consumer proposals. Again, we're talking about consumers here. I saw a stat, I can't remember where recently, but in the old days, I'll say before the 2009 amendments to the Act, I think the ratio of people filing bankruptcies to proposals was 80-20 in favor of bankruptcies. Okay, so 15, 20 years ago, 80% of insolvency filers in Canada were bankrupts. The other 20% were consumer proposal debt restructuring plans. I will tell you that in the year 2025 now, that number has completely flipped. 80% of insolvencies now are consumer proposals. 20% are bankruptcies. So it's a pretty drastic change in 15, 20 years. And if you're asking why, well, I'll give you a couple reasons. So first of all, I mentioned earlier the difficulties around the surplus income calculation, and it can be quite punitive, and I have to be careful what I say here, but I really do think that in a lot of cities in the country where cost of living has skyrocketed, people just this sounds utterly ridiculous, but people cannot afford to file bankruptcy. Why? Because they can't afford that monthly payment. What the consumer proposal does is it stretches it out. Please, like, don't misunderstand me. I'm not saying this is a loan, but it's almost like a car loan. If you go get a 6-year car loan, your loan payment on a monthly basis from a cash flow perspective is going to be lower than a 3-year car loan. So what would you rather do? File a 5-year consumer proposal and kind of spread out the pain, or have to pay as a first-time bankrupt 21 months, right? It can be pretty hard for people to pay the surplus income in 21 months. Then they end up on probably either a mediation or a conditional order, meaning they're still paying and their bankruptcy is not over till they're done paying what they should have done. So the increased cost of living, and in my respectful opinion, kind of the standard's still pretty low, that has pushed a lot of people into filing a consumer proposal, just from a cash flow perspective. They need that 5-year plan to pay. Some people would argue as I mentioned again earlier, it's all coming together, see? Trustee fees. Some people would argue that the trustee fees are driving more proposals. I don't necessarily agree with that, but I made the comment earlier. Remember, I said a trustee firm can't survive on these $1,800 no asset, no income bankruptcies. Bankruptcies tend to be more labor intensive. Like our firm, our people, we have to put more time into the bankruptcy files. There's more monitoring. There's more stuff that can happen. Those files are harder from a recovery perspective, from a trustee fee lens. The proposals, tend to take less work, although not always. And when you think about it, I mean, the first $1,500 plus 20%, we can make a good recovery on those files. It's a volume business in consumer insolvency. You got to do a lot of these things to make a buck. Um, the average consumer proposal is probably 350, $375 a month. So what's that? That's about a $21,000 file. So the trustee fees on an average consumer proposal are probably going to be $5,400. Okay, so $5,400 to run a 5-year plan. We got to do a lot of those to make a buck, right? We got lots of staff, lots of lease costs, and there's all this other stuff. So I do think the fees have come into this. But the other thing I'll say with respect to my regulator, the bankruptcy tariff has not changed. I don't even know how long because it predates me, but the bankruptcy fee tariff has not changed in like 25, 30 years. So imagine that. Imagine in your practice, I'm getting emotional here. Imagine in your practice, trying to run your practice, charging rates, your hourly rate from like 1998, right? Good luck. So part of the problem here is that the tariff stayed the same. And that means that trustees, if we're going to do bankruptcies under the summary administration tariff, we have to be as efficient as possible. We have to run that thing efficiently to try to turn a profit. We're private organization, right? We may be licensed federally, but we're in business just like you guys. So I do think that the antiquated tariff has unfortunately pushed some more, trustees into kind of doing some more consumer proposals. Now, the other side of that is one of the factors in determining whether an automatic discharge is appropriate. Sorry, let me step back. One of the reasons that a trustee or a creditor could oppose a bankrupt's discharge, and it's straight out of the BIA, I think it's section 173, the debtor could have filed a viable proposal. Okay, that's right in the act. So what does that mean? It's a sentence. It's a sentence in a hundreds of pages of legislation. But the debtor could have filed a viable proposal. To me, that means the bankruptcy system in Canada wants debtors to strongly consider filing a proposal to give their creditors an enhanced recovery. Because generally speaking, not always, but almost most of the time, proposals do give creditors a better recovery. And it makes sense, right? Because the creditors get to vote on the proposal, whereas in a bankruptcy, there's no vote. So in order to entice the creditors to support the proposal, you kind of need to show them that they're going to get more than their other options, which are either their standard legal remedies or a forced sale liquidation process, i.e. a bankruptcy. So if the creditor is more comfortable that the proposal is giving them their best shot at a recovery, they're going to go for it. And so proposals do put more money back in the system. So remember, BIA says debtors should file a proposal if they can. And I think as an industry, we do a good job of talking to the clients about this and making sure they understand that, that remember, I said honest and unfortunate debtor, but that doesn't mean that the debts weren't incurred and the people used the bank's money and they should pay something back, right? It makes sense. So as much as there's a criticism about trustee fees and there's a lot of issues around the tariff, which is being reviewed, by the way, I do think the bankruptcy fee structure is antiquated and it's led to sort of the proposal ratio getting much higher. There's another issue around this, which is unlicensed debt consultants, which is the third point on my slide. This has become a huge problem in the country. It's starting to change now, and the current superintendent of bankruptcy, Elizabeth Lang, she's really turned her attention to this. But the problem is, how do you regulate the unregulatable? Is that a word? These people aren't licensed. There's a bunch of debt advisors out there that here's the game. I'll just tell you. So let's say you have some debt and you're on Google and you're looking around for a debt advisor, right? And hopefully you find a licensed trustee, but you might not. You might find one of these other parties. And they're going to sort of suggest that they can help you get out of your debt. But the Bankruptcy Act says that only a licensed trustee can file a bankruptcy or a consumer proposal. So that's not me being arrogant. Like the BIA says, we are the only ones that can do a proposal or a bankruptcy, okay? But you've got these other parties out there that aren't licensed. So, Mr. Debtor, we're going to help you. We're going to get you out of debt. We know about this thing called a consumer proposal. We're going to help you with this. We're going to collect all your information. We're going to prepare this nice little proposal for you. And then we're going to refer you off to our trustee friend down the street. Now, there's a lot of issues around this, and I'm going to be careful what I say here. Trustees are a part of this, right? Because our industry takes a lot of referrals from unlicensed parties. And the reason is, if you think about it, just very basically, I told you our industry is a high volume practice, right? We need lots of volume. And where are consumers getting the most information these days? Online. So if you have a problem, good chance you're going to go online, start Googling. So really, it's a race online to see who can get their name up the page and who's going to get to the consumer first, right? And if one of these, and I'll be honest with you, these unlicensed folks do tend to attract more people, sort of newer immigrants to Canada, people perhaps don't have financial sophistication. If an unlicensed consultant gets to someone first, they may convince them that their plan is the best way. And what they'll do is they'll charge a fee up front. So they'll take their little cut. Then they'll refer it to a trustee. I think our industry has realized what a problem this is. I do think we're starting to cut them out. BDO, we don't take these files. Okay, we haven't taken these files for years. It's a hot button issue. The superintendent bankruptcy is all over it. I do think the tide is starting to turn. The OSB has done a good job in recent years of putting out more education, more material about the value of working with a licensed trustee. If I wanted a lawyer, I would want to come to one of you. I wouldn't want to come to some guy on the street saying, well, I'll give you some legal advice. Then I'm going to introduce you to a lawyer, right? So it's been a big problem over the last 10, 15 years. And these debt consultants love to push people in proposals to bring my rant back full circle. That's another reason why this 80-20 thing's flipped, okay? I just put creditor response to proposals as an industry trend. Because proposals are 80-20 now, creditors have realized that, hey, this is how these insolvencies are happening. By and large, most of these are consumer proposals. So we better take an active stance. We better vote on these things. We better pay more attention. And I do think creditors have moved the needle in the last 3 years post-pandemic. I do think the creditor response has become more aggressive, meaning the creditors are negotiating harder now. They're submitting more counter offers. I don't think they're taking as many initial offers. For instance, if a debtor puts out a $200 a month consumer proposal, years ago the creditor might have said, "Oh, fine, $200 a month." Now they're pushing back. They're saying, "Wait a minute, we've looked at your budget. You can afford $300 a month." So I do think the creditors are doing a better moving the needle. I talked a bit about the tariff review. This is on Elizabeth Lang's radar. She does recognize, I think, that the tariff does need to be reviewed. The OSB's been working on that. It's a difficult thing to change legislation. We talked about the Yukon Exemptions Act. I mean, this stuff does not happen overnight. Our industry's hoping, I say this cautiously, like 2026, that maybe this happens, but there's a whole bunch of legislative parliamentary processes that need to happen. So it's been a grind. Along with the tariff review, just a final point here. The threshold for summary administration assets, which I told you was 15, I think there's consideration to push that up just because inflation, right? I mean, that should probably be 20, 25,000 by now. And Division 1 debts, the threshold is 250,000 excluding your primary mortgage. There's talk of pushing that up perhaps to $300,000 just to kind of move things up with inflation. So those are some hot topics. And I thank you for listening to me for the last 75 minutes. And now we do have some time for questions. So I see one in the chat here.
Yeah, thanks, Chris. One in the Q&A so far, so I'll just read it out. With the exemption, so we're going back a bit, can you explain more about the purpose of the residence exemption? I'm struggling to understand the 40K, 12K versus 3K amount,
Yeah,
and what purposes do these amounts serve the process?
yeah. Sorry if I glazed over that a bit. So what the exemptions do is they reduce the amount of equity that the trustee is entitled to realize. So basic example, in Alberta, if your apartment's worth 100 grand, you're going to get a $40,000 exemption. So the creditors are entitled to 60, 100 minus 40. And there's two ways to get that. Either one, the trustee could try to force sale the property to get their 60 grand. The second way is the bankrupt can actually repurchase their assets, meaning the bankrupt could actually pay the trustee $60,000 over some period of time to retain their asset. Okay. But what the exemption does is it reduces the amount of the equity in the asset that needs to be realized for the creditors. So you can see in the Yukon, even if property values are lower in places, that Alberta exemption goes way further. And even BC, 12 grand in the city, right? Like that's not very much. So my only point there was $3,000 is very low. And the effect of that in the Yukon is it creates a lot more equity probably in a property, and it makes it harder for the person to repurchase their equity because it's more expensive. So that might be a factor that would push that particular individual into a consumer proposal. I hope that makes sense. You can type a follow up if it doesn't.
Thank you. Another question. In a consumer proposal, as opposed to a bankruptcy, who performs the role of the trustee?
Good question. So the licensed insolvency trustee would still be the gatekeeper, if you will. Under the act, it's actually called the administrator, capital A. So our role is administrator of consumer proposal or trustee of a bankruptcy, but it's the same. It's a licensed insolvency trustee that's performing the role.
Okay, another question. So if a high tax debtor who is not in an automatic discharge situation takes on additional non-income tax debt, they would dilute the income tax debt below the threshold for non-automatic discharge, thereby obtain an automatic discharge.
It's a good question. We got some folks are thinking out there. So that's why I chuckled. Um, yes, in theory. So the tests are quite prescribed, right? Again, it's $200,000 and 75%. It has to be both. I would never advise this, by the way. But again, here's a good point to make: is that um, the trustee or the administrator in our role as a licensed insolvency trustee, we're different than lawyers because we don't. There's no legal privilege in our relationships with clients, right? Like we're the referee, we're walking the tightrope, trying to balance the interest of all the parties, and we're there to get a recovery for the creditors. So a client can't really tell us anything that they might tell you, okay? So I would never advise someone to do this, first of all, but that doesn't mean someone else wouldn't, and that's okay. But here's the thing you got to remember is yes, they could dilute the denominator, right? They could increase the denominator, but then the question is, how did they do that? And in what period of time did they do that? Because the Bankruptcy Act has certain look back periods, 1 year and 5 years. So we can look back up to 5 years, okay? And I call it a glass bowl. Like it's almost like a fish. When someone is going to file a bankruptcy, they need to know that all their affairs, really for the last 5 years, are sort of in that glass bowl, and people can see it. And if they can't see it today, they might see it tomorrow, right? It depends. I said it's a bit of a self-policing system. Stuff can come out of the woodwork. So if a person was going to go incur, say, a $30,000 bank loan or credit card and kind of run it up over a short period of time, you're probably going to get some questions from that creditor who's going to say, well, wait a minute, you just opened this account 3 months ago. And how did it get from 0 to 30 grand? What did you do? And then there's going to be some uncomfortable questions, right? So cause and effect, like you got to remember there's an effect to everything. Now, sometimes naturally, Ryan, the debt can be diluted over time, not through any nefarious circumstances, just maybe a person's borrowing more, they have a business. But I would say an intentional dilution can be risky because of this look back period. A person might have to give some more information about how that happened.
That's the questions that are there for now, but I'll give it some time. I'm trying to think of something I can ask. Not always clever, but I guess one question I had that's kind of maybe kind of a dumb question, right? Is there some legislation where being able to do certain things by licensed professionals? The Immigration Act is an example. Is basically licensed professionals on exception. Is that it for trustees, or if someone comes to a lawyer wanting to do these, you still have to retain a licensed trustee? It might be a very stupid question.
No, no, it's not. I mean, there's a difference. I talked about these debt consultants, right? Um, who are unlicensed. They're not licensed trustees. They're not operating under the BIA. They're private enterprise, sort of a middleman, right? But I don't view the legal profession that way at all. I mean, there's often times where a client will consult us and they might raise a legal issue. And we want to be careful, right? Because as I said, there's no privilege. So sometimes I don't, and I don't say this in a dishonest sense, but sometimes I don't want to hear too much, right? And I might say to a client, I can see what you're saying, and you might want to seek independent legal advice on that. I'm not suggesting to sort of hide anything, but maybe there's an issue with a property or who paid for the property, or you might want to look into some options around that. So the legal profession is a very important player in the insolvency world. Now, of course, lawyers can't file a proposal or a bankruptcy, but it certainly helps for you to know what they are, to speak to your clients about these options, and perhaps based on your knowledge of them, one of the options might look better than the other. So you might say, hey, consumer proposals probably make sense for you based on your situation, but you should go talk to this other guy, the trustee, right? So that's a different situation than the debt consultant thing that I talked about. I think that's what you're asking.
Yeah,
Does that make sense?
yeah, that makes sense. Thank you, thank you. I don't see any more questions. So it's a little early, but I know a lot of people are busy and would be excited to get back to their work. So we'll thank Chris for his time. Again, a small token of our appreciation will be coming from the Law Society of Yukon. And once again, thank you everyone for attending yet another session of a CPD of continuing legal education for the Law Society of Yukon. And have a wonderful day. We will hope to see you soon at the next CPD event. Thanks.
Thank
On
you.
Thursday, I'm told. Thanks.